In politics and war, we get our allies where we can find them. And today, believe it or not, one of our biggest allies in support of the Second Amendment is Hunter Biden. That's right, Hunter Biden, the son of Joe Biden, the President of the United States, the anti-gunner-in-chief himself. Let's talk about Hunter Biden's attempt to use Nysurpa versus Bruin and the Second Amendment to get out from under drug-related charges associated with possessing a firearm while being a user of illegal substances. Let's talk all about the Hunter Biden case in the United States District Court for the District of Delaware when we get right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say a top 5 finalist in 2 separate categories for the 2024 Gundies Awards in Las Vegas. First category is Top Male Influencer in the Second Amendment space, and the second category I'm a finalist in is indeed the Top Voice of the Second Amendment. I am proud to be a finalist in both categories. All right, so big news here. The United States Department of Justice, under anti-gun President Joe Biden, has filed a major brief in the United States District Court for the District of Delaware in front of Judge Norica, very strong judge, who's already, by the way, I should mention Judge Norica, has actually, she's the one, you may recall, actually enjoined Delaware's ghost gun provisions on the ground that we have a fundamental Second Amendment right to make our own firearms. Same judge is overseeing the Hunter Biden case where he's been indicted in the District of Delaware for being a habitual user of an unlawful substance while also possessing a handgun. Specifically, he is accused by the federal government of violating 18 U.S.C. 922G3. You know, we've talked a lot about 922G because that is the general laws associated with what are known as prohibited people, prohibited persons, meaning those people that are on the list under 922G, including 922G3, which is what Hunter Biden specifically has been charged with. Those people on the prohibited person list are not allowed to possess firearms while they're on that 18 U.S.C. 922G list. Hunter Biden has been accused of being on that list because under Section 3, if you are a habitual user of an illegal substance, you're not allowed to possess a firearm. He is accused of possessing a firearm while he was a user of an illegal substance, and therefore the government says he should be convicted and go to prison. Now, what's interesting, of course, is that Hunter Biden and his lawyers, and Hunter Biden has very good lawyers, very high-end lawyers, no problems with the attorneys here, it's very smart. They are arguing that under the Second Amendment and the methodology of Heller and Bruin, Hunter Biden cannot be convicted because the relevant statute, the gun control law of 18 U.S.C. 922G3, is unconstitutional because obviously at the textual level, it interferes with the ability of Hunter Biden to exercise his right to keep and bear arms, because if he cannot possess, i.e. have a gun, well, he cannot keep a gun or bear a gun, which means to carry in public. So therefore, at a textual level, his ability to exercise his right to keep and bear arms is interfered with by, indeed, this 18 U.S.C. 922G3 law. As a result, you know what happens. The burden of proof shifts. The burden of proof to justify the gun control law as constitutional goes from the plaintiff, in this case, it's the movement, Hunter Biden, criminal defendant, and the burden shifts to the defendant to show that as a matter of history, long-standing history going back to 1791, which is the year the Second Amendment and the entire Bill of Rights was ratified and went into effect, going all the way back to that point, there is some historical analog laws that are well established and representative and long-standing. They weren't outliers. They were actually laws on the books that were enforceable. And the burden is on the government to say, here is the laws in 1791 or around 1791 that were on the books, and they've been basically, for all intents and purposes, on the books throughout American history, throughout America, long-standing, ordinary, understandable laws. And I always use a kind of an example here is, obviously, you can never use a gun to commit murder, so you don't have a Second Amendment defense to a murder charge if you use a gun. That's the sort of thing that the court is looking for, some sort of long-standing understanding of what the Second Amendment doesn't protect. And again, murdering people with a gun would be, to me, a classic, easy, understandable example where you do not have a Second Amendment defense if you shoot someone with a gun outside of the context of self-defense. And cold-blooded murder is what I'm talking about, and I think you understand that. Okay, so let's turn back to Hunter Biden's argument. So Hunter Biden filed a motion, which we covered about a month ago, saying that the indictment indictment involving 922G3 should be dismissed on the grounds that the law itself, the statute itself, violates the Second Amendment and cannot satisfy the Heller-Bruin standard of text first, burden shifting to the government, and then government has to come forth with historical analogs to justify the law. Hunter Biden's argument is essentially that there is no long-standing law at the time of the founding, the relevant time period, that would bar habitual illegal drug users or anything of the type from being able to possess firearms. Well, the government has now responded, and let's just say that I think the government is in some trouble here because their arguments are not very strong. They're clearly grasping at legal straws. So to begin with, they try to say, well, Judge, 922G3 is very, very narrow. It's not a big deal. It only applies to habitual drug users. Doesn't matter, because remember, whether or not a law is a broad ban on guns or a narrow ban, it doesn't matter, because either way, if it's an infringement as defined by 18th century lexicographers and dictionaries, that means, of course, something that destroys something or hinders it. So if you're not allowed to have guns, even in a narrow set of circumstances, that does in fact constitute an infringement, as in the right of the people to keep and bear arms shall not be infringed. That is an infringement. So the text is implicated even if the ban is narrow. Whether the ban is narrow or broad, it doesn't matter for the purposes of Second Amendment analysis. And so the first argument the government raises is really kind of silly. This argument says it's just narrow. It doesn't matter if you only violate one person's Second Amendment rights. That is too many. That is not a no. That is a no-go under American constitutional law. And of course, that includes the Second Amendment. Then the government moves on to try to argue, you're going to get a kick out of this, folks. You're going to get a kick out of this. They go, are you ready for this? I want you to pause for a moment and hear what I'm about to say. They rely on the Statute of Northampton yet again that was enacted in England in the year of our Lord 1328. Did you hear what I just said? 1328. Then they rely upon a English militia statute called the 1662 Militia Act in England. So here you have the American government in the 21st century is relying upon literally a 1662 Militia Act and a 1322 Act called the Statute of Northampton to justify 21st century gun control law. Well, aside from the fact that these are English laws, and the last I checked, we threw the English out long ago to become Americans. And as the Supreme Court has repeatedly says that although the English had a long-standing tradition of private firearms ownership, the reality is Americans with the Founding Fathers expanded the scope of the right to keep and bear arms beyond what the English understood it. But beyond that, let us just pause for a moment. We have talked extensively about how the Second Amendment derives as a matter of positive law from a law you're very familiar with called the 1689 English Declaration of Rights. As a reminder, the 1689 English Declaration of Rights arose when the Catholic King James II tried to disarm his political opponents who were Protestants, and he was dethroned. He was kicked out as part of what's known as the Glorious Revolution, which brought the Protestant king and queen, William and Mary, to the throne. And in conjunction with Parliament, they agreed to and enacted the English Declaration of Rights, which included the right of the people, well, really the right of Protestants in England to have guns could not be interfered with. But again, the point is, have you noticed how the U.S. government has conveniently ignored the 1689 English Declaration of Rights, which maybe they should have mentioned since the two statutes they're talking about are from hundreds of years earlier, the 1662 Militia Act and the 1328 Statute of Northampton, both in England and both come long before the enactment of the 1689 English Declaration of Rights, which from my review of this brief, I don't see a reference to that. Wonder why? But beyond that, let us carry on as to why it's absurd to even think these are the relevant laws. First of all, Militia Act speaks to militia duties. That has nothing to do with disarming people that are allegedly intoxicated or are addicted to a drug. So I don't even understand how that's analogous. We also know that the Statute of Northampton has been rejected repeatedly by even the U.S. Supreme Court. They rejected the Statute of Northampton as relevant case law, or I should say relevant law, for interpreting the Second Amendment, because All the statute of Northampton did was bar terrorizing people with guns, such as you can't go into the middle of the street and shoot the gun out over and over and over again in the middle of the street just for fun, because you're going to scare your neighbors, and that's terrorism. So you can't abuse and misuse a firearm, which is common sense, and no one would approve of that. But that's essentially what the statute of Northampton is about. And by the way, keep in mind that there's a very important footnote we've discussed before in Bruin that says, to the extent there's any ambiguity in the historical record, the presumption is the Second Amendment prevails and the gun control law fails. Specifically, a discussion about the Sir John Knight's case, which is an English case interpreting the statute of Northampton in England. There was a debate about what historically that meant, and the Supreme Court basically said, look, to the extent there's any debate about what a historical record means, we are going to defer always to the text, and the unqualified command of the language of the Second Amendment itself that says the right of the people shall not be infringed. Unqualified command according to the U.S. Supreme Court itself, not Mark Smith, not the Four Boxes Diner, the Supreme Court itself. So to the extent there is any airy-fairy, wiggly historical record here, the Supreme Court has already said, when in doubt, the text of the Second Amendment prevails and that modern-day gun control law should fail. The next interesting thing here, again, is they're trying to say that there's some long-standing rules about using drugs and alcohol, but here's the reality. Let me sort of give you what I think is the conceptual right answer. The two things to understand about 18 U.S.C. 922G as it relates to like drug users and all that, as I see it at the end of the day. The first is, I think, the Rahimi case, which you know deals with 922G8, dealing with domestic violence restraining orders, and that's before the Supreme Court. Now, I think the Supreme Court's going to come out and say, look, if there's an actual finding of fact after a long, extensive due process and a trial and witnesses and expert reports, blah, 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 an extensive process, like a criminal case, for example, any person is found to be a violent danger, physically violent danger, then I think the Supreme Court says, if that's the case, we can disarm you. We can even put you in prison, because violently dangerous people that are understood to be violently dangerous, well, we're not going to let them have guns, and we're going to restrict them because they're violent, dangerous, and a threat to society in a physically violent, dangerous way. Not a metaphorical way like the Democrats say, oh, Donald Trump is a danger to democracy. No, that's not what the Supreme Court's going to say. They're going to say a physically violent, dangerous way is the only way you can disarm anybody after a long due process approach, like a criminal trial, for example. The other sort of thing to keep, and again, it's very hard for me to connect the dots between someone who uses drugs or uses alcohol or misuses the thing. Not that I support misusing or abusing any of these things, by the way, but the reality is I don't quite see how using these kinds of drugs gives rise to someone who's violently dangerous. I will say I have some concerns on the current Supreme Court, because I think there are several quote-unquote conservative justices who are generally good on the Constitution and the Second Amendment are generally not big fans of criminals, so that is kind of a little bit of a tension we should just keep in mind. I don't think it's a huge deal at the end of the day for the Second Amendment movement, but we do have to realize there are some justices on the court that are not very sympathetic to criminals and are pretty good about, for example, letting people get put to death and not stopping death penalties, the execution of a death penalty sentence, and putting people to death, things like this. So there is sort of a law and order component among some of the Second Amendment justices on the court, as I see it. So we got to be aware of that tension between they probably don't love illegal drug users or drug dealers, but they do like the Second Amendment. So be aware of that sort of possible internal tension on the Supreme Court. But beyond that, let us also say one other thing. The only conceptual historical record that I have seen that I would consider to be the least bit credible, I'm not sure this would rise to the level of justifying a federal law, but there is some authority out there that you're not supposed to be drunk with a gun or drunk and doing certain things. It's kind of like you're not allowed to drink and drive and be drunk, that kind of stuff. There may be some authority out there, I haven't studied it extensively, but there may be some authority out there in the 18th century that says that people were not allowed to be using guns while they were drunk. That is different than using guns while you're drinking, or using guns, or I should say having guns in a place that serves alcohol. That's a far different cry than being drunk with a gun. Again, that's probably the closest analog laws that I could even come up with as it relates to people that possess guns and are habitual illegal drug users. But again, let's see how the history plays out. But right now, I don't think the government's argument is very strong. The only other point I want to bring up here is that two of the cases the government also relies on is, of course, the U.S. versus Rahimi case, which, again, we'll see what the Supreme Court does with that. And they also rely upon, I should say, the government tries to distinguish a Fifth Circuit case called the United States versus Daniels, where the Fifth Circuit had held held that 18 U.S.C. 922 G3, which is exactly the law that Hunter Biden's challenging, was unconstitutional as applied to marijuana users. So Judge Noreika here is probably going to consider seriously the rationale of that Fifth Circuit Court of Appeals case down in Texas and Louisiana, which deals with this exact same statute of 922 G3. And keep in mind that Judge Noreika has proven to be pretty good on the Second Amendment. Again, she is the judge that enjoined Delaware's ban on quote-unquote ghost guns, which are just do-it-yourself, make your own gun at home. And she is, I think, the first judge in American history, as far as I know, to actually find as a matter of law under the Second Amendment that you and I, as Americans, have a fundamental Second Amendment right to build, to make our own firearms. Although I think that's always been understood to be the case, we've never had a reason for a court to rule, and she did so in our favor. So I think she's a very serious judge. Bear in mind, this is also the same judge that effectively blew up the Hunter Biden plea deal on the taxes and the guns, because she's the one, when Hunter Biden and all the lawyers in the Department of Justice showed up with their sweetheart secret deal, she started asking a series of questions. And once she asked the obvious questions that any good lawyer would have asked, or any good judge would have asked, the Hunter Biden sweetheart plea deal blew up, and that was game over. I'm sure many of you have seen me talk a lot about this on Fox News. This has been a popular topic for the last 6 months that I've had to cover extensively as part of my appearances on the Fox News channel and the Fox Business channel and so on. So you're probably familiar with what I'm going to say because I've said it quite a bit on TV. So anyway, there we have it. The only other one, I'm now going to digress just slightly about who is the lawyer for the Department of Justice in this case. Just because this is a nerdy, geeky point, I want to flag something. The lawyer that submitted this brief on behalf of the Department of Justice is David Weiss, the special counsel. Now, you may recall in a separate issue that Jack Smith, the special counsel that's been designated with prosecuting President Trump, and is prosecuting President Trump for various things, there's a real question as to whether or not Jack Smith has the legal authority to even be functioning in his role as the special counsel prosecuting Donald Trump. Now, the question people have asked me, I'm going to answer it now. Why is it that David Weiss gets to be special counsel and he's able to act lawfully, but Jack Smith arguably is not acting lawfully as the special prosecutor, special counsel against Donald Trump? And the answer is this. David Weiss, before he became the special counsel looking into Hunter Biden and the like, he was already appointed by the President of the United States as the U.S. Attorney for Delaware, and he was confirmed by the United States Senate. So he was nominated by the President of the United States. He was confirmed by the U.S. Senate under the Constitution. So he was already a U.S. Attorney approved by the President and the Senate, and therefore when he just went from being the U.S. Attorney of Delaware to the special counsel, there's no debate that he had the authority already because he had been blessed off in that process of the President and the Senate signing off. In contrast, the special counsel attacking Donald Trump, Jack Smith, he was not a U.S. attorney. Jack Smith has never been nominated by the President and confirmed by the Senate for anything that I'm aware of. So he was just plucked out of being a prosecutor, I think, over in Europe, as I recall. I thought he was in like the Nuremberg Criminal Tribunal or something like that. So one of those nonsense international tribunals I pay very little attention to, although my alma mater, NYU Law School, I think generally likes those things. It's not my cup of tea, shall we say. Nevertheless, the reality is this. Jack Smith was never a U.S. attorney and never was bestowed with that kind of authority that David Weiss is. And that's why David Weiss, as a special prosecutor, cannot be attacked for acting without the proper constitutional authority and doing what he's doing. But Jack Smith can and is being attacked. And I do think if the Jack Smith stuff involving Trump goes to the Supreme Court and is resolved, I think there is an interesting question as to whether or not Jack Smith's authority will be upheld, or whether or not they will dismiss him as saying he's not allowed to do anything he's been allowed to do, and all of his work has to go in the trash heap because he was acting what is known in the law as ultra vires, which means beyond the scope of one's legal authority. So anyway, little digression. Hope that was helpful. I know it's not a Second Amendment issue, but it's a geeky constitutional thing I wanted to flag for you as to David Weiss, who signed this brief against Hunter Biden. So there you have it. All right, folks, hope you enjoyed something here today. Make sure you follow me on X at 4Boxes Diner. Make sure you subscribe and resubscribe. A lot of people are getting kicked off the subscription list for some reason. And again, feel free to share this video with your friends. Thanks for joining us here at the 4Boxes Diner.
Orders up. Table 2A.